programs is charged with protecting America's workers by ensuring that those who do business with the federal government fulfill the promise of equal opportunity. Our dedicated staff works to advance opportunity, promote diversity, and enforce the law. Programs is charged with protecting about 20% of the American workforce. As our country invests in its infrastructure and rebuilds from the pandemic, OFCCP is redoubling our efforts to enable all workers to access good jobs, free from discrimination. The historic $65 billion Congress authorized for infrastructure projects will increase the number of contractors under OFCCP's jurisdiction. This anticipated growth in the contractor workforce underscores the agency's need for resources. After reaching its lowest levels of staffing in decades, we are actively hiring over 100 people this fiscal year. Since the creation of OFCCP in 1965, our country has made significant progress in expanding equal opportunity. Yet discrimination remains a substantial barrier. In the last fiscal year, the agency recovered nearly $32 million for over 24,000 workers. To support an inclusive recovery, OFCCP is working to promote greater compliance, empower America's workers, and rebuild our staff. As our nation invests in its infrastructure, OFCCP is reinvigorating its construction enforcement and has scheduled over 100 construction evaluations. Through a renewed mega construction projects program, we will provide proactive compliance assistance to expand access to jobs on some of the most consequential projects. Through DOL's Good Jobs Initiative, we assist federal agencies in promoting equal opportunity in their infrastructure contracts. OFCCP is taking significant action to promote greater compliance during this critical time. On Equal Pay Day, we issued a new directive to emphasize the importance of contractors' long-standing responsibility to proactively audit for pay equity. Through OFCCP's review of pay data and our interviews with employees and compliance evaluations, we identify violations that would not otherwise come to light. We found systemic pay discrimination in over a third of discrimination resolutions this administration. For example, last December, we resolved pay discrimination allegations with Allied Barton Security Services, providing $1,175,000 to over 2,200 female, Black, and American Indian security officers. In February 2021, in a settlement with Google, we obtained $3.8 million from more than 5,500 workers after finding pay disparities and hiring barriers for female employees and Asian American applicants in software engineering positions. In January, OFCCP and Eeoc launched Hire, a hiring initiative to reimagine equity, to expand access to good jobs. The U.S. economy has added 7.9 million jobs since the start of this administration, yet many workers from underrepresented communities still face disproportionately high unemployment. At a time where many employers are searching for talent, Hire will identify proven hiring practices that advance equal opportunity and assist employers in finding the talent they need. This includes removing barriers for workers with disabilities and veterans. The pandemic has had an impact on mental health for many Americans, and we have an opportunity to transform how we address mental health at work. To promote compliance, OFCCP recently launched an electronic contractor portal to certify compliance with annual affirmative action program requirements. On March 31st, the agency issued a new directive to promote consistent accountability and efficiency in compliance evaluations. We have long prioritized active compliance assistance to contractors and empowering workers through outreach and engagement. To achieve greater progress, OFCCP must rebuild our staff. Compliance officer levels are down more than 50% from a decade ago. President Biden's budget for 2023 requests over $147 million for OFCCP to support much needed hiring to meet our increased responsibilities. In closing, I thank you for your support and I look forward to your questions.
Thank you for your testimony. Under Committee Rule 9A, we will now question witnesses under the 5-minute rule. I will be recognizing subcommittee members in seniority order. Staff will be keeping track of time, so the members adhere to the 5-minute rule. Please be attentive to the time wrap up when your time is over and remute your microphone. First, I will recognize the chairman of the full committee, Chairman Bobby Scott from Virginia, for 5 minutes for your questions.
Thank you, Madam Chair, and I want to thank both of our witnesses for their testimony and their lifelong commitment to equal opportunity. First, Chair Barrows, during the Trump administration, there was a rule that was promulgated that allowed faith-based organizations to discriminate in employment. What was wrong with the rule and what did you do about it?
Well, thank you, Chair Scott. And I believe that you're referring to the religious guidance that the Eeoc issued at the end of the last administration. And that was a guidance that addressed a really important issue of religious discrimination across the board. And yet I was concerned about the manner in which we approached that it was rushed through in a very abbreviated period. I think something like a 5-day formal vote for a very lengthy documents, and really thought that it would have been terrific if we could have addressed some of the, taken the time, first of all, to really delve into that issue, but also address some of the really pressing problems that we've seen with respect to religious discrimination during the pandemic. For instance, we had heard from the Sikh community about issues regarding PPE and those folks who, for religious reasons, may have facial hair, and how to balance those issues. So there were just a number of things that I thought we could have done, and I had some concerns, frankly, about the race to finish it in the time that we did.
Well, so there seems to be almost a redefinition of the victim of discrimination. When I was growing up, you went to a restaurant and weren't served because of your ethnicity, you were the victim of discrimination. Now it seems if the restaurant owner can't discriminate against you, then he is the victim of discrimination. Why is it problematic to protect the right to discriminate rather than the right to be free from discrimination?
Well, absolutely. The Civil Rights Act of 1964 protects the right to be free from unlawful discrimination based on race, color, national origin, religion, as well as sex. And at that time, as you, I'm sure, are well aware, a lot of the arguments about segregated lunch counters, et cetera, were based in arguments about, religious arguments about the need to segregate racial populations. And so absolutely under our statutes, race discrimination is protected even if there is a religious argument put forward. And that's true of the other bases as well. There's not a question about that with respect to our statutes.
But the point is that the victim of discrimination is entitled to be free from discrimination. We're not protecting somebody's right to discriminate. Director Yang, the Office of Federal Contract Compliance Programs has a more aggressive mission, and that is proactively affirmative action in government with government contractors. What kind of affirmative action would you require, and how would you enforce compliance with the affirmative action requirements in the law?
Thank you for that question, Chairman Scott. Under the 3 authorities that OFCCP enforces, we enforce both non-discrimination requirements and affirmative action requirements. And our requirements ask federal contractors to affirmatively recruit underrepresented workers in a variety of ways to increase the qualified talent in the applicant pool. We ask contractors to track metrics to measure progress and diagnose concerns. Our requirements do not in any way impose quotas and in fact prohibit them. We do enforce these affirmative action requirements through our compliance evaluations. We conduct routine evaluations through a neutrally scheduled compliance evaluation, where we have the opportunity to work with contractors to provide compliance assistance and to identify opportunities for them to expand access to jobs, to understand where they may have barriers to promotion or unequal pay. And that's the kind of work that OFCCP is focusing on in federal construction contracting as well.
Thank you. And Madam Chair, if I could get both witnesses to provide for the record an analysis of how their budget requests will allow them to get their job done, I'd appreciate it.
Absolutely. Without objection, Mr. Chair.
I yield back.
Thank you, Mr. Chairman. I now recognize the ranking member, Mr. Fulcher, for 5 minutes for your questions.
Thank you, Madam Chair. And I have a question for Director Yang, please. So in November, the office of OFCCP published a proposed rule to rescind the previous administration's rule protecting faith-based organizations that wish to bid on federal contracts. That rule ensured faith-based organizations could apply for federal contracts on equal footing with other employers without having to compromise their religious beliefs. Can you provide assurances to this committee that OFCCP will not discriminate against faith-based organizations who wish to participate in federal contracting?
Thank you for that question. OFCCP is firmly committed to protecting religious freedom as well as workers. I'm happy to share our proposal. We are in the rulemaking process, so I am limited in what I can say, but I can explain the rationale and our proposal to return to.
So Director Yang, then why propose the rule change if that's what you believe?
Well, the reason we propose the rule change is we'd like to return to the practice in place for nearly 18 years under both Republican and Democratic administrations to apply the text of the religious exemption to the case law as it evolves so that we can make sure to adhere faithfully to the law.
So do you believe then that faith-based organizations have a rightful place in competing for federal contracts on equal footing?
Absolutely.
Great, thank you very much. I appreciate that comment. A follow-up question, if I may. March 15th, you issued a directive requiring federal contractors to perform a pay equity study. It wasn't defined. And to provide that study to OFCCP when the contractor is under audit. This directive further prohibits a contractor from asserting the attorney-client privilege if an attorney prepared that audit. This directive was issued without the required notice and public comment. Can you please describe on what authority that you issued this directive requiring a new major obligation that appears to arbitrarily decree that the contractor loses its right to assert attorney-client privilege and did it without notice of comment?
Thank you for that question. We issued a directive to explain a longstanding regulation that requires federal contractors who are supply and service contractors to conduct in-depth analyses of all their employment practices. So that includes hiring, pay, promotion, and other areas. And that's conducting a proactive audit.
So Director, if I may then, why avoid the notice of public comment?
Well, the regulation already exists. And so simply what we did through the directive is highlight to employers the importance of complying with that existing regulation.
Do you see value in having that public comment? Do you think that rule should be there?
So there was public comment on the regulation that exists that does already require the pay equity
But
audit.
you don't think there needs to be any public comment for changes to that?
We will be actually looking at our whole supply and service regulation, including this provision that I'm referring to,
With public comment?
and we will have a full public comment process.
Thank you, Director Yang. Follow-up question, if I may, I'd like to go to Chair Burrows, please. So Chair Burrows, more than a month ago, Ranking Member Fox wrote to you requesting information about EEOC's plans to return to in-person on-site work. Fact remains, we have 2,000 EEOC bargaining unit workers that still haven't returned to in-person on-site work after more than 2 years. Your written testimony admits that by keeping field offices closed, EEOC has failed to reach some of its most vulnerable workers. When will you put that back in place, the in-person work?
We are, right now, we have returned our directors to work in the physical offices. Everyone at the EOC, all 2,000 plus of us, have been fully working during this pandemic period. So the fact that our offices are closed does not mean that we have not been working.
I'm out of time, so forgive me, but just to close that, do you not see the value of having your employees back at work?
Absolutely, and we're currently in negotiations to bring all of our bargaining unit folks back in as well.
Thank you, Chairman Burrows. Madam Chair, you go back.
Thank you, Ranking Member Fulcher. I now recognize myself for 5 minutes. Director Yang, women, particularly women of color, are severely underrepresented in construction apprenticeships and jobs. This is a result of various factors, including inadequate recruitment, hostility, sexual harassment during apprenticeship programs and on the jobs is something I've had many conversations about over the years, as well as pernicious gender bias. So does OFCCP evaluate construction apprenticeship programs to identify gender-based discriminatory barriers in recruitment and hiring? And if so, does OFCCP plan on using FY23 funding to improve oversight and monitoring of construction contractors to address these barriers?
Thank you for that question. OFCCP has made it a top priority to strengthen our construction enforcement for the reasons that you mentioned. Women, people of color have historically been underrepresented in good jobs in the trades. And we've been building our relationships with the contractor community in the construction space, unions, worker advocacy groups, and we understand some of the systemic barriers that we need to overcome, and it will take all of us. OFCCP knows we can't do this alone, and we're here to help federal contractors and workers. Apprenticeship programs, which you mentioned, are a critical part of creating the talent pool for the major infrastructure projects that we have. OFCCP will go into some of our most consequential projects, which we've called mega projects. We go into communities even before the contractor is selected. We form committees working with community-based organizations, local governments, members of Congress, to ensure that everyone understands the job opportunities that are available. People from all communities learn about the apprenticeship programs and other job training opportunities so that contractors interested in bidding can be competitive. So that's a very important opportunity we have to help ensure people from all communities have access to these critical jobs in their communities. We've scheduled over 100 construction contractors for compliance evaluations. And during those evaluations, we do review data to look at the hours worked. So that's utilization across various demographic groups. We can help identify where in an apprenticeship program, women may not be getting sufficient training, or people of color may be dropping out of the apprenticeship program and assigned to lower paying jobs, rather than the higher paying jobs the apprenticeship program was designed to support them in. So this is a key priority.
Perfect, thank you. You actually answered my follow-up question about how OFCCP is supporting inclusivity in those apprenticeships. So thank you for that information. Chair Burrows, in the last administration, there was a decrease in EEOC staffing levels, but also a dramatic decline in the pending charge backlog. So I'd like you to talk about that. Does this contradiction mean that the prior administration implemented policies that elevated expedience over workers' due process rights? What has the current commission done to address this issue?
First of all, every single one of those charges represents an individual who has been harmed and is coming to us for help. And sometimes, frankly, people share with us things they haven't even told their own families. And so we have to take that very seriously. We also have to, part of that, frankly, is understanding that we have to manage the charge inventory. We have about 250 charges coming in daily, to give some sense of perspective for those roughly just north of 2,000 workers. And so while looking, I'm not sure the answer with respect to the past administration. Looking forward, we are absolutely going to treat those charges with the respect that they need to have, but also is why we are so focused on getting more frontline staff to address that issue.
Terrific, thank you. I'm going to go back to Director Yang briefly and go back to the problem of the lack of women in the construction trades and ask if you are addressing the issue of once the people get to the work site and face discrimination, how does OFCCP address that issue of discrimination at the workplace once women get through the apprenticeship program and get to the job site?
Thank you for that question. When we do a compliance evaluation, we will typically go on site to the construction work site, which is very critical. We will learn things through those reviews. In one case, for example, Black women were not allowed to use the restroom on premises. Everyone else was. They were told they had to go a mile away to use the restroom. They found feces in their trucks, and no one was able to help them with these issues until we came in. We conducted the compliance evaluation, and we were able to ensure that the employer took the steps necessary to stop that kind of harassing behavior. We do a review, both of are people getting the opportunity to work. In other situations, Black workers were told to show up every day, but they weren't assigned to any jobs, even though all these other workers from all kinds of other backgrounds were getting paid, getting assigned out. They had to wait all day with no pay.
And thank you, Director Yang. I'm over my time and yield back. Thank you. Next, I will recognize Representative McLean from Michigan for 5 minutes for your questions.
Thank you, Madam Chair, and thank you, ladies, for being here. I appreciate your time and effort. I need to get a little context in terms of the verbiage that we use. You keep talking about systemic. Can you give me the definition of what you mean when you say systemic?
Well, with respect to the EEOC's enforcement, what we mean is when we look at broad patterns or practices, that's the language of our statute, patterns or practices of discrimination that when you address them can affect a large number of people. Sometimes if you get a change in that area, it can actually have an effect in an industry because a lot of folks follow industry leaders, they follow, the news. And
so you're not using systemic in the way that it is blatant across all lines and 100%. I just want to make sure that although we have issues, there's no question. I mean, I am a woman, I am in the workplace, I have my own business, right? When I hear systemic, I'm thinking that it's high volumes. I'm thinking that it's everywhere. It's more the norm than the abnorm. You're using systemic in the sense that if we make a minor change, we can have a maximum effect on it. Am I correct in that understanding?
Well, certainly we are not looking at it everything that an employer does is absolutely discriminatory. That's not what I mean.
Thank you. Thank you. I just wanted to make sure because when we use words, our words are extremely powerful and those words resonate. So I just want to make sure we were on the same sheet of music. I want to switch a little bit. Ms. Burrows, you state in your testimony that the EEOC works to advance racial justice in the workplace by promoting merit-based practices. Correct?
That's right.
Good. I mean, I would, because merit, if we're using merit as an outcome-based practice, we're taking a look at the result. My question is, do you believe that all employees should have the ability to grant merit-based pay raises?
I think you mean all employers?
I'm sorry, all employers, yes. Okay. So to me, when we're making raises, when we're going to go and promote raises, do you believe that the employer should look at the outcomes and base it on merit? That would probably be one of the best non-discriminatory practices, because if we look at the output, we don't care if you're, who you are, what you identify, we're looking at the output, and that would be merit-based.
If an employer is making a merit-based decision, that does not violate our laws in any way.
Good. I'm glad. Will you commit to supporting employers' ability to grant merit-based pay raises regardless of negotiated wage scales in place of employment?
We certainly work with employers and see them as partners. And nothing that you have raised to me sounds as though it would violate our laws. Good.
No, that's good. And I think a lot of times there's a misnomer on the easiest way to not discriminate is to take a look at what the output is, right? But you also mentioned in your testimony that the EEOC is working hard to address pay discrimination in hiring in promotions, right? We want to make sure that everyone's on a level playing field, correct?
That's right. We've found a number of cases in which women and persons of colors have been discriminated against in the sense that they were given lower pay for doing exactly the same job.
Right. And we all know that that's not a good thing, right? Do you, would you agree that if an employee has a master's degree, that they may be paid more than somebody maybe who doesn't? Do you believe degree level matters, educational matters in the hiring process?
Well, it really depends on what the job is. And so if it's relevant to the job, it certainly may. And if it's not relevant to the job, then there wouldn't be a basis to make that distinction. And one of the things that's really important is for employers to be making that decision in a fact-based way.
And how do you determine relevancy?
Well, it depends on what the jobs are and what the job is and what's necessary to the job.
But I think the definition, since we're holding these employers to a very high standard, I'm out of time. I think relevancy matters, and the criteria we use to make these decisions need to be played out. But thank you for your time. I appreciate it.
The Representative Eeoc's back. Thank you. Representative Adams from North Carolina, you are recognized for 5 minutes for your questions.
Thank you, Chair Bonamici, for convening this important hearing. The EEOC and the FCCP do critically important work to protect our workers from employment discrimination, and I certainly appreciate the opportunity to discuss that work today. So I want to thank all the witnesses. Chair Burrows, I note that the EEOC's FY 2023 budget justification mentions multiple ways that it plans to increase diversity in employment and recruitment. This includes plans to build strategic partnerships and alliances with stakeholders such as HBCUs and MSIs for that recruitment. So can you first talk about the importance of EEOC's outreach to HBCUs and MSIs? And then can you speak to the outcomes and any lessons learned from EEOC's FY 2022 and current HBCU MSI engagement and outreach?
Thank you so much for that question. As someone who's, both my parents spent their entire careers working for HBCUs, I am really passionate about this issue. And we have been very pleased to work together with the administrations, the White House initiative in this area, and have been doing a number of things, in particularly do a great deal of outreach every year to HBCUs. We have, obviously with our own respect to our own hiring, make sure to get our own information to them when we have a job opening for internships as well as permanent positions, and really are looking to strengthening that partnership as we lean into the hiring initiative to reimagine equity. I think that we can never, in terms of lessons learned, never do too much in terms of making sure that we are on the radar screen for HBCUs in that area, and it has been enormously helpful. I should also add that we have a lot of staff that are alumni of HBCUs as well.
Great, well, thank you. So turning to FY 2023, can you provide more information about what the Commission's HBCU outreach goals are for 2023 and how the EEOC will use allocated funding to improve outreach in FY 2023?
Absolutely. Well, we will certainly continue to do what we have been doing, and have also looked at we have an equity plan to make sure that we are reaching as broadly as possible to include as many of Americans' population as possible. And the part of that is doing that together with HBCUs. We have a longstanding, very popular program called Youth at Work, in which we partner with actually also high schools, but also colleges, and want to increase our efforts with HBCUs in that area, because it has been enormously helpful to, as people are just beginning their careers, to make sure they understand their rights. And that has paid dividends for sure.
Okay, so EEOC serves more than 500,000 of my constituents in Charlotte, North Carolina. And as you know, the coronavirus pandemic has really challenged much of the ways in which we thought about the workforce. Workers and employers across the country tapped into creative and innovative approaches to fulfill their day-to-day operations. So can you talk a little bit about how or whether COVID-19 pandemic impacted the day-to-day work of EEOC, including its investigations and education and outreach efforts to relevant stakeholders?
Absolutely. Well, like every other employer and every other, frankly, person in America, we were impacted with that. The first impact was in March of 2020. We moved to practically complete, had to close our offices for the safety of the public, for the safety of our folks. But what we learned to do is to conduct a lot of our business remotely. We invested in remote, sort of platforms so that we could continue to do that. We've had wild success with our mediation program remotely. Folks have liked it a lot, and we've gotten good recoveries in that. We've also done some trials remotely. We've done them in person and remotely during COVID-19. What the courts wanted, we were able to provide, and continue to look for creative ways to do that. We've expanded our outreach as well. I am, though, considering, still concerned, as I said in my testimony, that there are some folks who have difficulty reaching us when we are not in person. And so we are looking very closely at that issue and looking forward to being able to reopen as well.
Well, thank you. I'm out of time in just a few seconds, but I just wanted to thank you and let you know I look forward to the work that EEOC will do in fiscal years 22 and 23. Thank you, Madam Chair. I'm going to yield back.
Thank you, Representative. And sticking with North Carolina, I now recognize the ranking member of the full committee, Dr. Fox, for 5 minutes for your questions.
Thank you, Madam Chairwoman. Chair Burrows, in a recent case, Amazon terminated an employee for making vulgar, offensive, abusive remarks to a female employee through a bullhorn, a video of which was posted on the internet. NLRB General Counsel Abruzzo saw a court order that would require Amazon to reinstate the employee. Last week, an NLRB administrative law judge ordered Amazon to reinstate him with back pay. Committee majority staff has indicated that the video is too offensive to play in a committee hearing. If it is too offensive to play here, one would think it is not appropriate for the workplace. His behavior and remarks would clearly seem to constitute sexual harassment under EEOC guidance. Do you believe such conduct potentially violates Title VII of the Civil Rights Act?
Thank you. So I am not familiar with the video that you referenced. Our laws do, Title VII of the Civil Rights Act has a long interpretation with respect to what is harassment. And as I said earlier, we take that very seriously. So if there were an incident of harassment, that person could file a charge and bring it to us, and we would evaluate. With respect to the broader question of issues that arise in that context, I would defer to the NLRA as to the NLRA issues.
So you have not seen the video?
I have not seen the video that you're referencing. No.
Okay, all right. So do you believe the employee may have been rightfully fired for such conduct?
Without context, and it's a very fact-specific undertaking, I'm not able to comment on that.
Is the EEOC prepared to address this case?
I'm not aware of whether, we certainly, I'll put it this way, we certainly will address any allegations that are brought to us. We are not, of course, at liberty to say confirm or deny under the statute whether or not we've received a particular charge because there's a criminal penalty involved with revealing that.
Okay. Chair Burrows, in 2016, the EEOC issued a requirement that employers provide very detailed compensation data on a yearly basis for each of their employees, a requirement that was abandoned after 2 years. EEOC apparently did nothing with the data it collected. EEOC later showed that it was extremely expensive for employers to collect this data. Experts have also demonstrated the data would be of no use to employers or to EEOC for purposes of Title VII or Equal Pay Act enforcement. More importantly, they've shown that EEOC has no ability to protect the confidentiality of this highly sensitive data. You've stated that you're considering reissuing this pay data requirement. Given the requirements of nearly identical work under nearly identical conditions that are necessary to support a claim of unlawful pay discrimination, what practical value is there in collecting this aggregate information at a tremendous burden to employers? How would any of this information be useful to EEOC in investigating or prosecuting a Title VII or Equal Pay Act claim? And please be specific in your answer.
Thank you. The Equal Pay Act and the Title VII of 1964 have been in effect almost 60 years. And in that time, we have cut the pay gap almost in half. And part of the reason, but only almost in half. And part of the reason it's taking so long is that we need more information on the law enforcement side to be able to effectively attack that very pernicious problem. And so one of the, frankly, difficulties has been the lack of specific pay data for the agency as we start to figure out how to focus our resources. Lily Ledbetter, for whom the act is named, received an anonymous note, and that's how she learned about it. The pay data collection is being studied now by the National Academies of Sciences. We do have effective and very talented folks who have checked the security for that and have also are looking at the pay data and are able to say that it would be very useful to us. With respect to exactly how that will be used, I do want to wait for the National Academies of Sciences to give us their recommendations. I think it would be unwise to get ahead of that. But it is.
Well, we'll look forward to getting your specific answers. And Madam Chair, I'm out of time, but I will be submitting some questions and we'd like to have timely responses. Thank you very much.
Thank you, Ranking Member. And as a chair, I just want to clarify the Ranking Member Fox's statement that the majority forbid somehow the use of a video. The majority party simply asked the minority party to remove expletives and they chose not to do so. But in any event, it's my understanding that the matter that was discussed is pending before the National Labor Relations Board and not the EEOC. So I struggle to understand how it was relevant. Next, I recognize Representative Hayes from Connecticut for 5 minutes for your questions.
Thank you, Chairwoman Bonamici, for holding this important hearing today. I would like to draw attention to the needs of caregivers. 2 out of every 3 American caregivers are women. They are disproportionately women of color and often from low-income households. Their work to care for children, spouses, parents, and loved ones is unpaid, and their contributions to our nation's economy is valued at over $470 billion. These caregivers face obstacles to upward economic mobility, and the COVID-19 pandemic has put the inequitable strain on full display as they have tried to balance their obligations of essential work, children, and their families. From December 2021 to January 2022, nearly 2 million women left a job, lost a job, or had not looked for a job because of the need for care for their children, compared with about 1.2 million men. For these caregivers that remain in the workforce, 61% report potentially illegal discrimination at work. The EEOC recently issued guidance with respect to caregivers. In the guidance, the Commission clarifies actions that would constitute discrimination against employees who are caregivers under EEO laws. Chair Burrows, can you explain the EEOC's reasoning for releasing this guidance and the impact it will have on caregivers' workplace experiences?
Thank you. Yes, we feel so strongly that that is really urgent now. We are fortunately, I hope, turning the corner on the pandemic reopening. And as we do that, though, there are many, many folks who are going back to the workplace or seeking to do so, who also have to juggle those caregiving responsibilities for children or for ill family members, elder care, et cetera. And so we thought it was really important in this moment, as we are all seeking to ensure that there's an equitable recovery, that everyone has an opportunity to contribute and to benefit from that, that we make clear the needs of caregivers and how our statutes can be affected by that. We do have a longer term caregiver guidance, but we wanted to have it in more accessible form and get it out now because it seemed like exactly the right time.
While I believe this guidance is a welcome clarification from the EEOC, how does your office plan to address potential increased reporting of caregiver discrimination given the heightened backlog of private sector charges? And do you believe the EEOC is adequately resourced to handle a potential influx of reports caused by this guidance?
Well, there's no secret that we are working very hard to manage a inventory that we stay ahead of, I should add. We get about 61,000 charges in the door, and we resolve about 62,000 charges in the door. This is every year, so we're a little bit ahead of the curve here, but it's obviously a lot to manage. We are focused on that, and part of and we'll be ready to respond to those issues. I will say that part of the reason to have the guidance out there is not just to let employees know about their rights, but also for employers to have some understanding of the responsibilities, so that hopefully, because most employers do want to get this right, that we can help them make sure that this is handled in the appropriate way so that we will get fewer charges.
Thank you. I want to shift focus a little bit here. According to EEOC data, race-based discrimination charges have consistently represented a third of the charges filed with the EEOC since 1997. This is approximately 30,000 charges alleging some form of racial discrimination, which indicates that race-based discrimination is still a significant issue within American workplaces. Yet, in recent reporting, some EEOC employees allege that the agency assigns low priority to race discrimination charges, in particular, charges filed by Black workers. Chairwoman Burrows, what is your response to these allegations, and what specific actions has EEOC taken to address them?
Thank you. Well, we absolutely prioritize ensuring that every single worker's charge is taken seriously and decided on the merits. So the response to our African-American charges somehow given lesser weight, and I can say for certain, not on my watch, we're not going to do that. I don't believe that has been a problem. I do believe that we need more resources to focus so that we can give that sort of service and those investigations can be concluded more quickly. But that is something that we took a look at and are going to continue to focus on. And part of the equity plan is making sure that those barriers that may be there to folks reaching us or getting through the process are things that we can really address directly.
Sorry, thank you. I'm out of time. Madam Chair, I apologize. I yield back. Thank you.
Thank you, Representative. Next, I recognize Representative Fitzgerald from Wisconsin for 5 minutes for your questions.
Thank you, Madam Chair. Chair Burrows, thanks for being here. Two things that in my own estimate that really suffered during the pandemic was, one is I think there's been a huge loss of credibility when it comes to the public health system. And the other thing I think that took a direct hit was protection for religious beliefs. I think it was dismissed or was negated by some of the policies. So with that being said, during the height of the pandemic, EEOC issued guidance on whether employers could require employees to become vaccinated. While the guidance recognized Title VII of the Civil Rights Act, and along with that, the assertion on religious objections to the vaccine requirement, your agency, and I don't know why, seemed to weaken the right to use this to quite honestly kind of put up a wall to those that were going to be vaccinated. So I'm just wondering, do you believe that that in fact happened? Or can you explain some of the changes in and around religious beliefs when it came to the pandemic?
So if I understand the question, Representative, that the EEOC strongly believes in protecting against religious discrimination. We have done that with our own workforce. We have provided information to the public about that, including about folks who may have a religious objection to receiving a COVID-19 vaccine. That's on our website, and we are constantly updating as new issues come up. We have also shared our own information about how we treat our workforces. We've made that public, and we certainly recognize those objections and apply the law when they are raised with us.
Do you believe that you changed the posture on what really was a responsive measure to religious beliefs, and took it a step further by saying, listen, we're going to kind of change the dynamics of what we consider legitimate and not legitimate when it comes to that exemption?
I'm not aware of what you're referring to. I'm sorry.
In February 2021, you removed a report from the EEOC website. That was something that was put together by General Counsel Sharon Fask-Gustafson and Commissioner Andrea Lucas. That was very specific and very comprehensive in saying, these are the types of things under a religious exemption that will remain acceptable. It just seems that this is one other area during the pandemic in which there were changes and shifts by the EEOC. And I'm just wondering if that was intentional. Was it revisited on purpose, or was it something that simply was that you believe never really happened?
So I believe that you're referring to a document that the former general counsel of the EEOC had included with respect to some invitation-only listening sessions that she had. After that, the full commission voted on a religious guidance document that we put on our website. So the document that you're referring to was with respect to a single, the general counsel and I believe a single commissioner.
So do you think it had anything to do with the actual pandemic and what we were in the middle of experiencing related to any of those policy changes?
I don't believe that there were policy changes set forth in the document that you're referring to, but the document that the full committee addressed, the religious guidance, which is on our website, does look in a very thoroughgoing way at a number of issues and sets forth the current position of the EEOC. I did hope that there were additional things we could include in that, including specifics about the pandemic, frankly, but the pace at which the commission voted on that document did not allow us to add some of the things that I would have loved to address at that point.
Well, I guess my comment would be, I hope it was not some type of knee-jerk reaction to the pandemic, or that there was some type of conscious effort to somehow, my word, water down kind of where the EEOC would be on this. Because that would be a great concern, I think, that I would share with many other of my colleagues on the committee. So, but thank you for your time. I yield back.
Thank you, Representative. I now recognize Representative Leger Fernandez from New Mexico for 5 minutes for your questions.
Thank you very much, Chairwoman, and thank you for coming and sharing the work that you are engaged in on behalf of all of our workers. Director Yang, the OFCCP recently launched a webpage that provides information on the employment rights of Indian and Native American workers. The website also describes OFCCP's efforts to connect Indian and Native American job seekers with employment opportunities on federally funded construction projects. As we look forward to the many projects that are going to bring the clean water, the broadband, the infrastructure that is sorely needed throughout America, but especially within Native American communities, I wanted to thank you for that resource, but I wanted to also ask you, how does the OFCCP plan to increase its efforts to conduct education, outreach, and compliance assistant activities to promote that recruitment, hiring, retention, and advancement of Indians and Native Americans as well as protect their employment rights?
Thank you for that question. We are very interested, particularly as the infrastructure investments are made, in working with our federal partners, so contracting agencies, to raise some of these issues. Not everyone is aware of the hiring authorities that exist for American Indians and Native Americans on projects located close to a reservation. And we are working to make sure both our partners across the federal government who are interested in supporting equity in their contracting process understand those opportunities as well. When we work on our construction enforcement, we are out in the community, in the field, bringing together the key leaders and organizations in those communities to make sure people learn about apprenticeship programs, training opportunities, and opportunities to work on the job. Internships for students are a critical way also for individuals to get into a field where they've been historically underrepresented. And we reach out broadly to many different educational institutions as well. So this is a very important priority for our office, and we have some very dedicated staff leading those efforts.
Thank you very much for that work, because I think it is key that we recognize that the Infrastructure and Jobs Act, I love the second part of that, the Jobs Act, right? That it is bringing both what our communities need to thrive, not just survive, but then to create the jobs within those communities. I am very appreciative of your mega construction project program that will help contractors and subcontractors make sure they create those jobs and invite our underrepresented workers, and that we also protect those civil rights. I wanted to turn now to Chair Burrows. There was a 2020 GAO report that found that there was a limited nationwide data on the prevalence and costs of workplace sexual harassment. We know it takes place and it saps our economy, right? It is bad. It is bad for business. It is bad for women. It is bad for men who suffer this discrimination and harassment. So I'm interested in learning more about the prevalence of workplace sexual harassment experienced by Latinas, by women of color, by Native Americans. In particular, whether these women are more likely to experience sexual harassment. While the 2020 GAO report acknowledged the data was limited, as an example, it pointed out that Native Americans were close to 3 times as likely to report experiencing sexual harassment as non-Hispanic whites. So this report also echoed the recommendations from the EOC's 2016 Select Task Force on the study of harassment in the workplace, by finding that the EOC should work with federal and or private partners to develop and conduct a national survey that includes the sex-based harassment. Can you tell us what steps the EEOC has taken in regard to moving on these recommendations so that we have a better understanding of what is happening in the workplace for Latinas, women of color, and Native Americans?
So I just want to say quickly that this is such an important issue and such a top issue for us. One of the things that we have done is to look at some of our data, which, to be clear, most people don't report. It's just the tip of the iceberg, but to look at our data and make sure that we could also link it to those instances where there are charges of retaliation. So sometimes, so that we can see, hey, is it connected? We are also, of course, working very hard in our investigations and as to the issue of intersectional harassment, because harassment is about power first and foremost. Often when people have multiple issues, they will be targeted for those reasons. So we've seen that in our work on farm worker women. We've seen that in our work on so many others. And I wish we had more time, but I'm happy to follow up with you on that because it's so important.
Thank you. My time has expired. I look forward to hopefully providing the budget resources that you need to conduct that data. Madam Chairman, I yield back.
Thank you, Representative. Next, I recognize Representative Mervan from Indiana for 5 minutes for your questions.
Thank you, Chairwoman. In 2017, a report on diversity in technology sector, the GAO, recommended that the OFCCP evaluate its approach for identifying keys for compliance reviews to better reflect changing workplace structures and location, such as virtual sites and non-traditional forms of employment. especially in the technology sector, and to include subcontractors in OFCCP Fall's 2021 regulatory agenda. The agency proposed adding a provision to Executive Order 11246 regulations that would require contractors to provide notice to the OFCCP when they award supply and service contracts. My question is, how will having information about the subcontractors advance the agency's mission to ensure equal employment opportunities, especially in rapid expanding industries such as the tech sector?
Thank you for that question. We have been working to improve our scheduling methodology, and that's how we select contractors for compliance evaluations. We use neutral criteria to try to identify where there may likely to be problems that are important for us to be looking at as an agency. Specifically for subcontractors, we have not had complete data on the dates of the time period of the contract for subcontractors. So in the past, the agency had not scheduled a large group of subcontractors for compliance reviews. And what we are doing for our next scheduling list that will be issued in May is we have included subcontractors by using the prime contractors' contract dates. That information is available in current databases, but it would be more helpful and accurate to have the dates of the subcontract. So the recommendation by GAO was that OFCCP explore data sources to better schedule the full range of contractors under our jurisdiction. The agency is working more broadly to ensure that our practices align with how workplaces operate today. We recognize the point that you raised about many employers are not tied to one physical location. The historic approach OFCCP has taken in our regulations is to look at one establishment at a time, and that we recognize may not align with how an organization structures its practices. So for example, software engineers in a technology company may not report directly to a leader within their physical location. They may report to a leader in a different location, and that leader may have authority over multiple establishments in different locations. And particularly after the pandemic, we know that more and more workers are working remotely in a full-time capacity. So one of the priorities we have in our supply and service regulation update, which is on our regulatory agenda, is really listening to contractors and understanding opportunities we have to modernize those regulations to better align with how businesses operate. Thank you.
I thank you very much, and I yield back my time.
Thank you, Representative. I do not see any more subcommittee members on the minority side. Is Mr. Mfume on the platform? Okay, then we're going to go to non-subcommittee members and start with Mr. Grothman from Wisconsin. You are recognized for 5 minutes for your questions.
Okay, I'm going to look a little bit into your enforcement of Executive Order 11246. Would that be more appropriate to ask questions to you? Okay, very good. First question I have, you break down people by ethnicity and race, correct? What ethnicities or racial groups are you looking for?
So our regulations ask employers to track data on demographic information by race, gender, ethnicity for their employment practices. And that is a metric that can help employers identify where there may be a problem in terms of a barrier to equal opportunity and how they're making progress.
Sure. Could you define the difference between race and ethnicity, or what groups you're looking for on the form?
Oh, by ethnicity, typically we're talking about Hispanic, non-Hispanic. And race, we are looking at, various racial categories.
Okay. First of all, with regard to ethnicity, Hispanic, non-Hispanic, what is the definition of Hispanic?
Well, for our data collections, we ask employees to self-identify. And so we ask employers to invite their workforce to identify for themselves what their ethnicity is or race.
Okay, so to give an example, only because it's so commented on, is if, say, when Senator Warren was applying for a job at whatever she went, Harvard Law School, I think, if she is 164th Native American, if she says I'm a Native American, we put her down as Native American on the form and she gets preferences over other people. Is that what you're saying?
So let me be clear, OFCCP's regulations do not promote or permit preferences for any workers. There are separate congressionally authorized preferences for Native American Indian workers near reservations. But apart from that, none of our regulations provide preferences.
Okay.
All we ask is data collection and we defer to the employee self-identification.
Okay, but you realize, of course, that these forms are used where people feel they have to hit targets on these forms, correct? You realize that?
Actually, what we are very clear about in our work with the contractor community is that these are not inflexible quotas. These are goals that help
They're
contractors
goals, right,
measure
right, right.
project. And
But if you-
race, ethnicity is not to be considered in any employment decision.
Okay. Are you not aware that people who advise companies on these goals tell the employers that they are goals that have to be met, or if they're not met, they could be subject to some litigation?
So under our enforcement authorities, we do not bring an action against an entity simply because they are not achieving those goals. Those, as I mentioned, are a diagnostic tool. They are not used at all for an enforcement action. Employers are actually asked to show good faith efforts to help reach underrepresented populations. So what we're looking at is, are you trying? Not, we don't bring enforcement actions
Well,
based
but
on
it-
what we've met.
Well, okay. We'll give you another. So you have no problem if somebody says I'm 164th Native American or 164th Hispanic, that the employer gets to check those off as being an Hispanic or Native American.
Well, let me be clear. For data collection purposes, it's a diagnostic tool. If there was an actual case or litigation focus that it was material as to somebody's identity, you would have a more, fact-based sort of.
Well, I am told by people who deal with this that that's what you do. It is open-ended, that you self-identify. And if you're 1/32nd Hispanic, you can check off Hispanic. And if the employer feels that helps them get to the target, they can hire you and get to the target.
Well, these things are not connected. So the employer actually doesn't know how you identify when making a hiring decision. Those are separate processes where the actual hiring officials don't know the identification of the individual. And that's very intentional to avoid the concern that you're raising.
You mean, if I'm an employer and I'm filling out the form, I have no idea who I'm dealing with?
So these are different people within the organization. So you have a hiring manager charged with filling a position. You have your HR department that would complete the paperwork in a separate process.
It's amazing that you don't realize how this plays out in the real world. But thank you. I guess my time is up.
We have, thank you, Representative Grothman. We have no further members in the queue to ask questions. I want to remind my colleagues that pursuant to committee practice, materials for submission to the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing. So by close of business on May 11th, May 11th, 2022, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the subcommittee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame, but please recognize that in the future that link may no longer work. Pursuant to House rules and regulations, items for the record should be submitted to the clerk electronically by emailing submissions to ed&labor.hearings@mail.house.gov. Again, I want to thank the witnesses for their participation today. Members of the subcommittee may have some additional questions for you. We ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days to receive those responses. I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days, and the questions must address the subject matter of the hearing. And I now recognize the distinguished ranking member for a closing statement.
Thank you, Madam Chair, and for holding this hearing, and Director and Chairman for being here today and for providing testimony. Just as a closing thought, I do remain concerned, Director Yang, of potential OFCCP discrimination regarding faith-based organizations, and just want to point out and serve as a reminder that that's a critical and needed component to the system. Just ask that you be mindful of that and see the value that they bring. Chair Burrows, regarding EEOC, we're still not back to in-person work. That's a needed component to that situation, and I think all of us have allowed COVID to manage us too long, and it's time to manage it. And so I just ask that you accelerate that process of bringing people back to in-person work. And also this situation where we appear to be looking to resurrect a defunct annual pay data collection system.
A defunct?
That is quite onerous on employees, the people who turn those economic wheels for us. And that takes me to my final thought. And that's just the overall culture that we appear to, and I'm saying the collective we here.
No, it's you.
Not being
you have
accusatory.
embraced.
The overall culture that we seem to be manifesting here. The federal agencies versus the private sector. Too often we seem to take this attitude that the private sector reports to the government in some fashion, but that's just not true. That's backward to the original intent, and that's backward to how our system works. And I think we all need to remember we serve the American workforce.
No, you don't remember that.
They're the boss here. And yes, there's bad apples out there on both sides. And so this is a system to try
but it's affecting us all.
to provide some oversight and help. But at the end, it's the American people that we serve. And all of us need to be reminded of that. And I thank you for your time and your work. I yield back, Madam Chair.
Thank you, Ranking Member Fulcher. I now recognize myself for the purpose of making a closing statement. I want to again thank our witnesses for being with us today. Under the leadership of Chair Burrows and Director Yang, the EEOC and OFCCP have taken critical steps to restore and strengthen workers' civil rights protections. Unfortunately, our discussion and the testimony today confirm that for far too many women, people of color, older workers, workers with disabilities, LGBTQI plus workers, they're still experiencing persistent discrimination in the workplace. These persistent civil rights violations are particularly concerning as Americans get back to work and recover from the pandemic. Moving forward, I'm committing to advancing legislative solutions and delivering the resources that the EEOC and OFCCP need to protect our workers' civil rights and to support our nation's economic recovery. Each of us should agree that now more than ever, we must take these steps to protect our nation's most vulnerable workers and make sure that all workers can succeed on the job free from discrimination. So thank you again, Director Yang and Chair Burrows, for your time and your testimony. There's no further business, and without objection, the subcommittee stands adjourned.
Okay, we can stop the share. You see that? Everybody see it? Okay, I'm going to say some things, and I'm not even going to go because I haven't done my hair yet. But what I'm going to say is here in Nevada is just truly criminal as states' rights and small businesses and you know, they have just transitioned all of the federal resources and everybody shares in a part of the wealth except for the children who are generating the money. And it behooves the shit out of me that I just really don't understand, as they have felt the need to come in and alter my devices in my home. There's just no reason why I should come to every device and have to put in a new password or have to write down the password or have to transfer the password. Are you serious? There are no other people living in my home except for me. So there's no way to be mistaken about who I am except for the administrative rights and authorities of network administrators here in Nevada, as they control everything that happens in my home. And I'm about sick of that shit. That's real. No one has the right to sell me a product and then it doesn't work in the manner in which it should work. And that's from phones to printers to laptops to MacBooks, whatever. The policies that they apply on people, that they put in groups, and I understand group policy because I know who I am, because I got taken for group policies and network administrators. Well, let's just say somebody saw a pot of money that I had possession of and they made sure they got it, even if I didn't get a benefit. And there was nothing I can do. As most people understand, if you're just part of the harvest, there's absolutely nothing you can do to protect your human rights in America, except for stand up and shout out. I promise you that. That's the only thing you can do. So who are we going to be in 2022? Innovative, creative podcasters, trying to ensure that actual people understand that there are just rules. And, you know, Roland Martin puts a young lady on his platform and he talks about how she was wrongfully expelled. And then he didn't share the process because every state, county, and city is supposed to have a process where someone can object and fight the expulsion. Hell, I've went to the county office of education and went to meetings within the school and had what do you think? Expulsions overturned. And I know the people I supported were grateful. One of them was a young man at Luther Burbank, and he became a doctor. But do you understand what the expulsion would have did on his record? He wouldn't be a doctor today. And in America, it's going to require e-provisionum, all of us, because none of us make it without all of us standing. And I'm tired. I'm tired of people standing on my neck as I witnessed George Floyd being murdered in whatever. The real deal is that there's a new murder every day, and failure to comply comes from slavery, boo. And I'm not a slave. And I can't even tell you how to behave like a slave. But apparently, network administrators would like to administrate my ass up in my home and tell me I cannot go live, and then give me no means of, advocating for myself. Just gonna let me know every time I get on someone else's stream that I can't live stream. And I consider that harassment. Boo. You ain't gonna break me, but I'm gonna break you. We are not gonna continue this shit in the manner in which they are dishing out the shit. And I promise you, if I get a complaint, my complaint was against Clark County, I guess. I have no idea. I don't know where this. Well, I say Clark County because the Popo work for Clark County and the network administrators who are looking in everybody's home. Just understand the power that we have given to CCSD, as COVID certainly happened. And in COVID, what happened in COVID? I'll tell you what happened during COVID. What happened during COVID was people were alarmed as deaths were certainly happening and people were certainly dying. And the real reality is that this is just America. You understand, boo? Understand me when I say this is just America. And we are who we are. And the real reality is that you are only who you are also. And in America, if you choose not to stand, then guess what? Someone will stand on your neck. Let's type that. SPAND. Stand. No, I have to put a D there. And then you die. That's real. Because that's what I put when I witnessed that last person being murdered by law enforcement, that he was shot in the back of the head. And I was amazed that we all witnessed that because it was a body cam or someone was recording, but guess what? We cannot change what is happening in 2022. That's not something. What hell, Martin, Megier, and all of the people who chose to stand up for civil rights, they ain't here no more. You get me? They're just not living. So, what am I talking about? I'm talking about equity and access. And no state has a right to abridge the liberties of the human beings, which they have been given the responsibility to ensure adequacy happen for. And when they ain't got no data, boo, to understand we're paying up the name. Understand these last folks in Clark County that gave themselves a raise, all their jobs stand on what they're doing right now is trying to encourage change and accountability, because bing, 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 human capital has been happening. And I promise you, it's just human capital. And the real reality is that we are only going to be who we are. And who are you in 2022? Apparently, you do not have any language to talk about who you are and what you have done. But you do understand what's happening, because people have been given the ability to do what? They've been given the ability to govern when they don't know how to govern. And failure is just an option. But when they would put so many children in the public school system and then not be held accountable for the outcomes, well, it's just a problem in 2022. You understand what the problem is? I do. And know that it is us who are measuring the ability to understand that perhaps the outcomes and the maintenance and effort have not been happening for the local community. And it is unacceptable when an African-American male be in his late 20s and gain custody of his child, and then hit that child so hard that the child hemorrhaged and died. And they wanted us all to know because they put him on the news and they showed him he was behind. But you know what? There was a white man and he had killed a 4-year-old and he had the baby in the freezer. But I was curious as to how that 4-year-old was not committed to any early learning process. But then I understood that childcare is widely embraced here. And as they have so many workers here in Nevada, that would ensure the sustainability of the entertainment capital of the world, boo. Know this, that they go upwards of 200% of the poverty index. And when somebody would get on and be in a public meeting and talk about they're willing to work with you to get you some free childcare, and I'm willing to understand that perhaps they have been working a little bit too long to create this inequitable situation. So no, freedom ain't never been free, and I understand just who I be. So sharing on Facebook would be my first major priority today. What's yours? I am free. And know this EEOC and how they work with federal contractors group to ensure adequacy and equity and equality and same opportunity to bid for the contracts. And when they sell land, it's some funny shit. It's not a nationwide call. They selling a piece of land. And it's almost like it was comical. It's comical because people bid and they weren't there, but the one who wanted the property, he damn sure was. And then he had an opportunity to outbid everybody that was there. And there were no additional qualifications except for how much he was willing to pay. Just like they were asking for people to put up $1 million and have a what, Head Start program, and how the Head Start person that has one Head Start here in Clark County, one, started right away when the money was up for grabs under the American Rescue Plan, that is, and started talking about how they had 34 Head Start centers. Well, they weren't Head Start. Maybe they would like to transition them to Head Start, but they were not operating like Head Starts because they were not opportunities for the people in poverty when they could go upwards of 200% of the poverty index. And I am not a fool, but maybe you wish to continue to deal with the fools that you're dealing with, quite frankly, when you show up like you don't know the rules. I'm just really trying to understand why you're there, boo. Because the house nigga and the field nigga mentality certainly exists here. When Black folks who do not attend public meetings, do not understand what's going on, but will not talk to you. And it's just, and when you do talk to the white folks, well, let's just say, it's unfortunate, but they believe your conversation is above their pay grade. And I want to clearly articulate where my pay grade is, boo, is right here with you. So wake up in 2022. What is it you're willing to do? Wake up, my friend. It is just me and it is just you. Stand in 2022. I'm going to go right now. Hey, find my podcast on Anchor. It is Parent Empowerment Hour. And then I'm also on Wisdom. But I have my YouTube channel, and this is where you are. But please